This conference will now be recorded.
All right. Well, thanks for joining us today. This is the start of the law discussions we'll be doing. And the purpose and goal of these is to help us better understand ourselves, as well as better understand our own thoughts and how to articulate them. We'll learn law along the way, but so much of learning the law helps us learn about who we are, what we think, and why we think it. And it's a great way for us to get an opportunity just to learn to articulate things, learn to understand ourselves better, and learn to understand how to live more according to our own internal principles. So the goal for this is that we'll have a fair amount of discussion. We certainly hope that everyone participates, and if people don't participate, I'll just try calling on you to get some discussion going. And it's an interesting thing in law school. There's very rarely a right or wrong answer. Most of it's just based on looking to articulate things, trying to understand, points of view. And as long as you have something to back up your feeling or your thought, it generally is a good thing. And again, we'll learn what the law actually is on a number of these things. Some of the things won't fully have answers, but discussing them will help us to better understand what the law looks at, the factors, and how it functions. And so when you talk, sometimes at the start, you may only be sharing what you think should be the way things are based on your own views, but those are very helpful in evaluating a number of the factors, again, that the law looks at. And so this process of discussing really helps to understand the law, because the law is not just a set of facts. It's a constantly evolving set of rules that govern our lives. And it's just super helpful to understand the way the law thinks and evaluates things. And ultimately it does that through people, judges, lawmakers, and others who think and act like us. And so again, the law is an interesting thing, and how much discussion there is. But the goal will be that we can hopefully pursue that. So we do, if you are able to, it's always helpful to have your video on so others can see you as well. It helps create a little community. But if not, that's understandable too. And then, can all of you see the screen? Did the screen share work for the slide that's there? Elias says yes.
Yep, I can see it.
Okay.
Yeah, I can see it.
All right, so good. So first, we're just going to look at a fairly normal scenario about Jim. And let's see. So Jim says here, I just got to move some of this stuff down so I can see it too. Jim just bought his first home, and sorry, my computer's going a little funny. Elias, could you actually read that for us? Since my computer doesn't want to do it, let me see it.
Jim just bought his first home. He is excited to go green. Let's see. Is it with? Yep. With his home, and he signs a contract to purchase and have solar panels installed on his home. When the crew arrives with the solar panels to install them, his HOA president delivers a cease and desist letter stating that he cannot install solar panels. The solar company says Jim also owes them for the panels regardless of what his HOA allows. What options, if any, does Jim have? And what options should he have?
Okay, so Elias might have insight into this one. He worked in the solar industry for a while. But let's talk for a minute about what should happen here. So the question is, should an HOA have the power to restrict you from putting solar panels on your house?
I would say no.
Okay, so Ryan votes no. Why do you say no?
Because I feel like it's your property, and I don't feel like it's, really, you're not necessarily altering it or causing any harm or anything irreparable to the HOA. I think it's an enhancement, and I think it's something that, again, that should be really the discretion of the homeowner.
Okay. Great thoughts there. Renee, what do you think?
Well, I've been in several HOAs, and in some cases, I'm happy that they have certain, I don't know what they're called, rules that make it so that your what do you call it? That everybody has a certain standard that they're living in, and so I think that for me, I think it would be fine to have solar panels as long as they're not as long as they look good and they're on the top of your house and not like in your yard or making the value of the property go down, that kind of thing. So
Okay. So you're saying yes, maybe, if it enhances the value but doesn't detract from it. Is that fair?
oh shoot, can't. I have to stay there.
Okay, sorry, I think my internet went for a second there. Roger, what about you? What do you think with the HOA and solar panels?
Yeah, I don't love the idea of HOAs in general, but I know that, at least from what I've experienced, they have deep interest in the aesthetics of the neighborhood. So installing a bunch of panels that might be street facing, I can see them taking great interest in the standard that Renee was talking about. But I've also seen them in a case in California where the panels were on the back side of the house and they weren't street facing, and the HOA still was upset about that. So I don't really know. I don't. This is interesting.
Yeah. So one other follow-up question to this is, I guess the question would be, should the HOA have the power to dictate what type of shingle you use on your house to make that consistent throughout the neighborhood? What do you guys think of that?
I would say that would be something that would fall in line with the aesthetics, right? I live in a place where the association, they dictate, they have to approve the color you paint your door. And I know there's bylaws and things that we agree to by the homes here. So I do feel that may be something that should fall in line with the aesthetic.
Okay. Alan, what are your thoughts?
I'm not very good on legal things, but I get this. I would assume it would depend on
we're just talking morally right now.
It just what's in the HOA bylaws for that specific place. If it says, that you have to have permission or something to put solar panels on, then I don't see how you can get around it. Usually you can, I think you can apply for exceptions. My father-in-law got really good at applying, so good at applying for exceptions in his HOA that they voted him the president. So I don't know. I guess it just would depend on what was in those bylaws.
Okay. So here's one other situation. Let's say that the HOA approved solar panels on one other house in the HOA, but they won't approve them on Jim's house. And the bylaws do say that they have the discretion to not approve them.
That's when I would call you, Austin.
But again, going from a moral perspective here, what are some of the things, we're just talking right and wrong for a minute. And what are some of the powers they should have? Elias, what do you think with that? They allowed it for one, but not another.
They need to allow it for the other. Just what, based on what I think's right or wrong. I mean, that's what I think. Okay. You allowed in, you should allow another, you know. And at the same time, I can see if they allowed one and if it was just garbage and they're like, we got to put a stop to this. But if it's not expressly stated within the CCNRs, then they shouldn't be allowed to disallow them, if that makes sense. But at the same time, regarding this scenario, I think any solar company, getting into the solar aspect of it, the solar company shouldn't be charging them. That's part of their job to make sure. I mean, they have to get permits with their local jurisdiction, and any solar company worth their salt should make sure it's compliant. And so if it's not compliant, that's on the solar company. If they didn't even know, double check before installing, it's on them. Yes, they need to follow up with a customer. Are you in an HOA or whatever? Let's talk with your, but that's my perspective. You know, I think they should allow solar from a property rights perspective, but if it's not expressly stated in the CCNRs, and I've seen things expressly stated, but it's really based off of a committee of 3 homeowners of a subdivision that has like 300 houses, you know, and they're dictating everything. And so how are those stated? And sorry, now I'm talking like an attorney. It's not clear. It's not black and white, but generally speaking, they should be allowed. But at the same time, I understand that HOAs are put together in many ways to maintain like an aesthetic standard and a quality that they all agree to, and maybe people are moving in afterwards, but still they agree to those CCNRs when they purchase that home. So I understand that as well.
Yeah, and so go ahead.
Is there any difference, and maybe this is what Elias was talking about, I had to step out, but in many cases, and maybe this isn't even the case anymore, but you used to have these PPAs where you essentially leased the panels, and the solar company Vivint, for example, was in many ways renting the space on your roof. So you didn't own the panels yourself. It was Vivint that owned them, and you just benefited from them being there. And these PPAs were like 25 years in length or something like that. And I think after the 25 years, you own them. So what happens in the case where it's not the homeowner that owns the panels themselves and they're just renting the space on the roof? Does that matter at all?
It's a good question. I'd say no, it doesn't. It doesn't really change the law in the end. There is obviously there's the homeowner. I think would have a greater moral claim to say I can do whatever I want with my house. I think the HOA would have more of a moral claim to say we can stop you from letting someone else rent your house or your space if you're not the true owner of it. But legally speaking, it doesn't end up making any difference. The law doesn't consider that factor. But it's certainly a good thing to think about because in some ways, again, you know, from a moral perspective, it probably should be a factor to look at whether you actually own them or not. And Elias did bring up an interesting point. We haven't discussed it. There's a second side to this issue about, well, even if his HOA does have the power to do this, can he be stuck with this contract? Elias is saying, no, that's on the solar company. They need to be the ones that have that responsibility to look at that. And so to go quickly, the short legal answer to this question about banning solar panels, HOAs have full power to ban solar panels inherently. Just meaning with the governing laws that are set up that authorize them, they can absolutely restrict and ban those. However, from a moral perspective, this issue became so vexing and states had so much friction over it with the HOAs that most states, if not all, have now passed what they call solar access laws. And so states have overridden HOA's power and said, okay, HOA, you can't ban solar panels outright, but you can require that they at least look good. And so it's essentially fallen where Renee's at. So there's a number of HOAs where you have to go through the Architectural Control Committee or whoever it is to get the appearance approved, but they can't outright ban generally. That's the case.
Hey, Austin.
Yep.
So, quick, I'm coming into this really late. Maybe you guys have covered this. So, does it depend on what type of building you have? Meaning, like, so the 55 and older communities, it's almost like they own, they have their own home, but they join up, they share a common wall, versus maybe someone who's in a multi-tiered housing unit. My understanding is, back when I was a mortgage broker, you owned inside the walls, the interior walls of your home. That's what you owned. Once it got outside those exterior walls, that's what the HOA owned. So like if there was a fire, you were responsible for the interior walls, not the exterior. So how does that play into it? You may have already covered this already.
No, it's a great question on shared walls, townhomes, condos type things. So in that scenario, if you have a townhome and you want to put solar panels on your portion of the roof, what do you guys think about that? Should you have a moral right to put solar panels on your portion? Let's say that you're 1 in 10 townhomes along the same roof line. What are your thoughts there?
I would still go back to that's your property. Obviously, understanding the bylaws and I mean what you signed in for, but I still see that as that's your property, right? I mean, if you were to sell that home, you're selling the entire home, and that would include the roof of the home. So that's at least my opinion or my perspective on that.
Yeah, no, I appreciate that. Because again, it's really interesting with property law to start to look at, in the end, what we do or don't actually own when we buy a house. I think almost every single one of us, when we purchase a home, we feel that we're buying the home and we get to do what we want with it. And the most common frustration for people in an HOA is that at the end, when they get that cease and desist letter, they say, what about my property rights? I thought I had property rights as a homeowner. And so it's always interesting. I say the number one call to a real estate attorney are people that are frustrated with some aspect of their HOA. And they always want to know if they're really stuck to that or if there's a way to get around it. And we use solar here because the law actually has agreed with most people that for some reason they feel that's a right that shouldn't be overridden in property. But HOAs can take away your right to have trampolines. They can take away your right to have certain colors on your house, require you to have certain looks, fills, trees, grass type, plant type, all kinds of things. And yes, in general, a lot of it is related to the look and feel. But we have more questions later that we might get to on other things they can regulate, activities such as political speech. Can you put a candidate sign in your yard, even if it ruins the aesthetics? Can you put the American flag out? Can you have a dog that's over 35 pounds, even if it's inside and nice and quiet, kind of thing? And so these are aspects of HOAs that get troublesome. But to John's question about the shared roof, yes, in general, when you buy a townhome, the law treats everything from the sheetrock in as what you purchased. And the other things, the shared walls and the common walls, they're what are called common areas. And the common areas actually have joint ownership in the law, so that every member of the community has some level of ownership in that common area. And so it might be possible, for example, to put solar panels on a townhome. But the roof you're putting it on is considered jointly owned, and you would have to get approval of the joint owners, which would be everybody in the HOA. So if you buy a townhome or condo, you actually buy fewer rights than if you buy a standalone home. You don't have all the same number of rights to that place. And in property law, one of the aspects they talk about is that they usually say buying real property, which is real estate, is essentially like buying a bundle of sticks. And the law allows, if you view full unfettered property rights, no HOA, no zoning, nothing, you can do whatever you want with the land as being 10 sticks, let's say, then you can actually purchase property where someone only gives you one of those sticks, or 2 of those sticks, or 3 of those sticks. And in the HOA, depending on the HOA, you are buying a property with fewer than the complete 10 sticks. And HOAs can go down and manage quite a few things. Again, the law will come in at some point. Constitutional principles will come in at some point and say, ooh, we really don't like that. But for the most part, HOAs can manage quite a few things. Are there any other questions, though, about this scenario? I guess we can talk about the solar company quickly since Elias brought it up. The solar company, it would really just depend on what the contract said. If the solar company said in its contract, we don't do any due diligence to see if you're allowed to have these or not, it's all on you, then the law would stick it to the homeowner and make him pay that full amount. So there are some solar companies that do that. The law is very much a freedom to contract type thing, and if the homeowner accepts the responsibility to make sure that solar panels are good, even if he doesn't understand that, he just signs that in the terms and conditions, he'll be stuck with that.
If your contract says that, don't go with them.
Correct. This is why you always read the contract. Always read the contract. But yeah, it really just comes down to what it says in there. If it doesn't say anything about who bears the responsibility, then that's where you get a court case out of it, fighting about whose ultimate responsibility it is. And in the case of door-to-door salesmen that come around, if the contract was silent, the law would probably place that responsibility on the solar company. In the case of if he contacted the solar company and just said, hey, I want solar panels, I'd like to buy them, and they sold them to him, it would probably be on him. So some of those factors the law would look at to say who's soliciting who's the one pushing it, to see who has that responsibility if the contract doesn't say otherwise. So, but are there any other questions with that? With the scenario? So if not, we'll go on to the next one. Renee, do you want to read that one for us? We're going to go into zoning. You'll have to go off mute though. Oh, might have lost Renee here. Does it work on your screen or not?
Yeah. Oh,
Okay.
let me get it this way. Okay, there. Okay, now I can see it. Mary is excited to inherit her family's 50-acre farm. Real estate has been doing well, and she has plans to develop the farm into houses for her and her siblings to live in, with 10 acres for each. When she approaches the city for a building permit, they deny her request, saying that the land isn't zoned for residential use. They tell her that if she wants to change the zoning, she must use 10 acres of her land for high-density housing, commit 5 acres to a city park, and include a commercial strip in the development. Mary has no desire to do anything of these things on her family farm. What rights, if any, does she have? What rights should she have?
Okay, so interested on this to hear your thoughts on the morality of what the city's asking.
So from where I stand, I feel that it's, I mean, I've seen this happen to some close friends of mine where they had to give, I don't know how much, of that property to the city to be able to do what they wanted to with their business. But I understand, I mean, you really don't have much control over it. So if you want to do a development like this, you're going to have to abide by the rules, that the city's going to put in place. So I don't necessarily feel that that's fair. I think that where I have a problem with it is they dictate and just draw really hard lines and say, this is exactly how it needs to be, and you need to plant these bushes, and this is the way it needs to. And they really don't consider the cost and the viability of the business and what that could impact. So I think that there should be a little bit more give and take with that. So again, in the end, I know that there's not a whole lot you can do with it, but that's just kind of the way I see it from a moral standpoint, that there should definitely be more discussion and more give and take.
So, John's perspective is this was an issue down in Utah County for one of the county commissioners, and they said it's one of the county commissioners that were running here 8 years ago or something like that said, if you want an HOA, belong to an HOA, but a city or a county should have no right to act as an HOA. In Salem City, you cannot have your house any closer to the street than the house next to you. Is one of the dumb laws they have. So to me, when you own property, you own the property. We've got some neighbors, and I use that term loosely because they're only probably 12 houses away from me, but it's 5 minutes to get there. A guy bought 5 acres, and he runs his construction company out of it. If I was one of his neighbors, I'd probably be pretty annoyed that he's got 6 semis that start up every weekday morning. But the bottom line is, you own that property. My moral position is, you should be able to do it that does not physically harm someone else. Meaning, if I become some type of business and I'm dumping chemicals into my, I'm dumping chemicals on my property, well, that's going to affect my neighbor because that will leach out. But I should be able to sell my property if I choose to sell it in a tenth of an acre, every 5 acres. The city should not have the moral authority to tell me how I can use my property. If I deem to give it to the city for maybe a tax break, an acre that would be a park, well, that's me making a contract or an agreement with the city. But for them to tell me what I can do and how I can use my property, I think is ridiculous. We're told in our county that we can't, I live on 40 acres of family farm that's been there in our family for over 100 years. And we can't build another home because we don't have enough road frontage. So this is where I'm going to say I should have the right to be able to have a cul-de-sac in my property, to be able to have multiple properties if I wanted to do it, or our family would want to. But I don't think, this is where I'm going to say cities are starting to become HOAs. 100 years ago, no one would have accepted anybody controlling their property in the city or from the city. I don't know where we got off the rails on that. So that's John's opinion and Blowhard opinion.
Yeah, well, thanks, John. We love to hear thoughts on these things. It helps bring up some issues. So let's say, for example, that a neighbor is smoking marijuana next door, you live close, you know, they're constantly blowing it over, and that might go to the physical harm side you talk about. But we can get into more emotional or other type harm too. What if they're playing loud rap music day in and day out and they live right next door to you? You know, what if they've just put inappropriate pictures all over their yard, and it's very, very disturbing to look at or walk outside. And we run into these interesting issues where, yes, we certainly have this aspect of property rights that's inherent in us, that we should be able to do what we want. But those really start to break down a lot. And I'd say that one of the things that breaks down property rights is as we grow closer and closer together. Because the closer we grow together as a country, the more we're impacted by people's decisions, and the more we can be fairly negatively impacted. And so there's the negative impact side. HOAs came about to start to address some of those things. But it's an interesting fallout to look at with zoning and HOAs, because there's a lot of discussion anymore about whether zoning is a way to help perpetuate racism or classism in America. Zoning, for example, here in West Valley is it's now majority Latino, Spanish speaking. And in the last little while, West Valley has started to take some aggressive stances on zoning, where right next to me, for example, they're doing a new development. Maybe 60, 70 years ago, they had done a development, that's the older homes we live in, and they'd actually stubbed a street to go in. The city said, we know one day this farm will be sold, so we just have a street right here to go in, have it paved to go into that property. And maybe 4 years ago, they built another section and had that section create a street that would go through perfectly to this other one. It was kind of a master plan type community. But then West Valley suddenly decided, hey, no, we want to change the lot sizes and require that every new home built here has a minimum floor print where it's got to be a certain size. And these houses, the expense of the houses shot up like crazy, and the expense of the lot shot up like crazy. And they no longer fit in this plan they had. And so now they have these two stubs just sitting there, and they've developed this new cul-de-sac in this area that doesn't connect to these two stubs. And you just have these two ugly stubs left sitting there. I guess one of them they kind of turned and took out as a stub, but in the end, they only want now in West Valley, in all the new homes built, they're trying to keep the people moving in at a certain income class. And so they're putting all these requirements on the houses. And if you go to cities like Draper or some of the other ones, they'll zone in such ways that lower income families can't move in there. And it's created, again, an interesting scenario where you start to get neighborhoods of certain classes of people, but you exclude other classes of people. And so it's one of the things to note, one of the issues about zoning is to start to look around and see if the zoning regulations are acting to exclude certain types of people from your neighborhood. And again, maybe that's what people openly want. They want people that will take care of their property or do other things. But it certainly produces an interesting scenario for America as we go around and look. But in general, to Ryan's point, cities have an incredible amount of power when it comes to changing zoning. Once zoning's approved for something, they don't have a ton of power to dictate what happens within that zone. They still have some, but not as much. But when it's a request to change zoning, they have no obligation to change zoning. And so they just will and deal and negotiate with you. They say, oh yeah, we'd like a new park, we'd like this, we'd like that. And whatever the city's looking for at that time is, if you want that zoning changed, that's kind of what has to happen. I'm certainly not a fan of this at all. From a freedom perspective, I'm very troubled by it. But it's very much a a real thing that's happening. So one of the questions I have with it is the Constitution, the U.S. Constitution says that no property shall be taken from anyone without just compensation. And that is a, that's just one of the constitutional rights, saying that the government can't take property from people unless they pay them for it. So the question is, if Mary inherits her 50-acre farm and the city won't let her build 5 houses on it, have they taken away any of her property rights that they should be paying for if they're going to deny that? And again, this is from a moral perspective. What do you think? Maybe we'll ask Rod. Rod, we're doing it where we go through and ask questions about what you think. So.
Well, that's interesting. Let's put it that way. I think the person needs to be compensated, fair market value, and whatever it takes to make it right. Whatever it takes to make it right.
Okay. Appreciate that. Who else has a thought there?
This is a point where I struggle. My great grandfather owned a whole bunch of property out by the airport, and the city came in and just basically said, look, this is what we're going to pay you for it. And there was really no recourse, right? I mean, they just said this is what's fair and this is the way it's going to be. But what I struggle with is just the appreciation of that property, right? I think this transaction took place 20 years ago, and now to think of what that property is worth now, I mean, it's just that's kind of where I have, where I really struggle with it is I just, I think that the cities need to take those things into account, right? It could either appreciate or I guess depreciate as well, but that's a struggle I have, where it was just single-handedly said, we're taking this, it's our property, here's your check, don't say anything else about it.
Yep. Yeah, the government's got a pretty heavy hand there. Roger, what are your thoughts on compensation? Oops. Should the
So
city
my question is, what's stopping a city, for example, give me a second, during the recession, when property values were, sorry, I'm in the middle of working out as well, when they were depressed, what's stopping a city from taking advantage of situations like that and not paying what would otherwise be a fair value? Does that make sense?
Yeah, so to answer that question just quickly, we have a very real life experience in my backyard. I'm really close to the new Mountain View corridor that's going in. It's not so new in some parts, but they're completing it through to I-80 right now. And basically they came through during the Depression, the last Depression, and they bought everyone's property when it was bottom dollar, kicked everyone out of their houses for the street. And then that sat there now for 8 years, that property with people kicked out. They didn't put the road through till 8 years later, but they bought it at the bottom dollar for sure. So is that a real thing? Absolutely. Do cities do that? Absolutely. They definitely look at that. So again, from a moral perspective, that's kind of one of those things of, wow, what's right or wrong? Because yeah, the price right now for the house is $150,000, but 6 years later it's worth $300,000, and all those people had to move at a time when that's all the money they got for the house.
So is there a time frame in which a city, in the case that you mentioned, would have to exercise eminent domain, or could the homeowner reasonably delay the process enough to where they could likewise game the market and get as much for the property as possible?
So to answer your question, there's nothing in place currently in the law for them to delay it. If the city comes in and says we're buying it, you can file a lawsuit, and that can delay things sometimes. That's really your only mechanism. But at the end of the day, no. So what happened to these homeowners? I actually lived in the ward half our ward was taken out by the road going in, and so all these people had to move, but they moved, their houses were empty, and then literally it was that the SWAT teams would go through and they'd do practices and they'd shoot their grenades in and blow up the windows and things in these empty homes. After they did their practices and blew up windows, then they tore them down, and then the land sat. But they very much made everybody leave then.
So my perspective is it seems like the power and the authority of eminent domain has been growing and growing over the years, and there aren't proper checks and balances to that. I mean, it's for these jurisdictions, and I mean, it's there are so many stories out there where people weren't compensated with fair market value, or it was part of the master plan of the city to do this, but they waited for the market to be at the bottom to gain, so that they'd be able to compensate these homeowners or business owners or farmers or whoever owned the land the lowest amount possible. And morally, it's not right.
No, you have a very good point that it's an issue that's been growing. Their eminent domain power has been growing, for sure. And this little slide here helps highlight one of the issues that the Supreme Court took up, where it greatly expanded the power of the government's eminent domain reach. But to go back to the question we asked earlier about if a city stops you from, if they don't change zoning and let you develop it, we're saying that they've taken away a stick, one of those sticks. Should they have to compensate you? There was a really extreme case where a company bought a place in New York. I think it was Grand Central Station or something. And it was an old train station. They bought it and they were about to tear it down and build this huge skyscraper on it. It would have, I don't know, made the land worth 20 times as much or something with a skyscraper on it. And the city, to stop it, because it was actually zoned for skyscrapers, so it wasn't a new zoning request or any of those things. What happened is the city came in and designated it as an architectural, historical type building. And once it's designated as an architectural historical building, you can't change it. You can't tear it down. You have to maintain it in its old state. And this was after the company purchased it. They came in and slapped that designation on it. So the company sued and said, hey, you just took away basically all of our rights. We can't do anything with this property anymore. It's just here as it is. You need to pay us for the loss of what we were going to do with this property. And it went up to the Supreme Court, and the Supreme Court said, no, as long as you have at least one stick left, we don't have to pay you anything for eminent domain. And so the Supreme Court said, essentially, we can take away all 99.9% of your sticks for your property, but so long as we leave you with that last little one, we don't have to pay you. It's not till we actually take title from you and take it out of your name. And so since then, there's been all kinds of things where national parks come in, and national parks will just suddenly be made over people's property. You own property there, but the national parks, so they don't have to pay you for the property. They don't take the title away from you. You still hold the title, but you can't do anything with your property. You can't build anything new on it. If you had a cabin there before, you can keep using it because the government, again, isn't going to take that away from you. But you can't do a single new thing on it. It's just yours, and you just lost basically everything with it, and they don't pay you for that. So to Elias's point, this slide here helps us highlight one of the Supreme Court decisions. This did not happen in Utah, but it did happen back east. It's a real case, and so I put it in Utah. But Ryan, do you want to read that one to us?
Utah decides it wants to create a new shopping center to help revitalize the economy. Utah identifies an area in Daybreak that would be ideal for the shopping center. but for the plans to work, Utah will need to utilize the property of 150 homes. Utah elects to use its eminent domain power to force the sale of the 150 homes. Utah pays fair market value for the homes it took. Do the homeowners have any rights to stop the eminent domain process? Should they?
Okay, so thank you. So we talked a little bit about this. It sounds like ultimately, and I'll tell you a little thing here, that the U.S. federal constitution says that the government only has power to take property for public use. And so if the government wanted to come in and say, hey, Austin, I'm taking your property, I'm going to sell it to Joe down the street, and it's going to be his property now, the court would say that's unconstitutional. And so the question here that this slide's getting at is a new shopping center considered public use? Because they will actually sell land to private citizens, but it's a shopping center for the public. So does that constitute public use? And what are your thoughts on that? Again, from a moral perspective.
I don't think it should be. I don't think that's right. Even though I know that they would justify, well, it's public use because the public's going to be able to use it, and they're going to justify it that it meets their master plan of what they want to do. They should be able to fight it. Those are my thoughts.
Okay, appreciate those. Any other thoughts with that?
We have a similar thing happening here in Davis County with the Legacy Freeway going through. And so, we have people, our stake president has to move because the Legacy Freeway is going to his house,
Yeah.
And so it does bring up some issues like the rights of the one versus the rights of the many.
Yeah.
And I can see that they've been trying to, not take out as many homes as they can, but at the same time, having I-15 be a parking lot when we're supposed to be moving, at 5 o'clock at night, that's also a difficult situation. So I really can see both sides.
Yeah. So with the road,
and I'm still.
It's a good point. With the road, that is historically considered to be just a straight up case of public use, saying, yep, roads are for public use. Anyone can get on them, anyone can use them.
I see.
So the government has eminent domain power to take houses for roads. There's just no question with that. If it was a toll road, that might be another story. There could be some more issues there, but just an open road, that is public use. But the question is, as a shopping center now, so the city says, oh, great, we can take this for a park. We can take this for a road. Oh, well, let's do a shopping center. And let's lease these to private people who make a lot of money off this. Is that now public use that you can take your homes for?
I see the difference. Thank you.
And so this is a question that the Supreme Court took up. I think the case was called Kelo versus New London. I could be wrong on that, but they had, in that situation, the development had some commercial, it had some residential even in it, where they were making new kind of condo style housing and things. And at the end of the day, the Supreme Court said, yeah, the Constitution says public use. It said, but what public use means is a public purpose. And so the Supreme Court essentially changed the use term to purpose. And they said, yeah, it's true that the public will be denied access to some parts of this development. They said, but at the end of the day, the city's going to make more in tax revenue. And tax revenue has a public purpose to it. So therefore, we feel it's constitutional and okay. And so to Elias's point, the scope of the eminent domain power just shot through the roof at that point, because now the city just had to show they'd make more tax money on it. And they were good to go. There still is one check on that citizens, and that is that was the federal constitution. Each state has constitutional restrictions on when the government can use eminent domain. And actually, many of the states are more restrictive than the federal government. And so you still have state constitutions you have to go through to see if their Supreme Courts, the state Supreme Courts, have adopted the Supreme Court's reasoning, the US Supreme Court's reasoning. So it is mixed among the states, but there are many states that allow the government just to come in and take your property if they're going to make more taxes in the end, or if they can claim that. And it is pretty concerning. It is one of the areas that I think we should definitely work to insert some checks and balances in, because at the end of the day, there's very little in the way of checks or balances on the government's eminent domain power right now. So here in this question, the only rights the homeowners would have to stop the eminent domain process would be if the Utah Constitution gave them some type of protection against it. But with the inland port that Utah just did, it basically came down and slapped this new designation on things. In that situation, in some ways, it makes things more valuable for some, less valuable for others. So it's a mixed bag of how it impacted people. But it is something that we see happening here among us for sure. So we're getting close to the end here, but we'll try and go through this one quickly. Roger, do you want to read this one to us?
Vineyard, Utah is a city planned with a lot of developer input. Vineyard zoning allowed for homes to be placed extremely close together, for only one side of some roads to have sidewalks, and for garages to open almost immediately onto the street. In addition, Vineyard did not leave any zoning for any church property, and so Vineyard has no church buildings in it. Do the residents or religious institutions have any claims against Vineyard? Should they?
Yeah, so this highlights the other side of zoning issues. I don't know if you've been to Vineyard. These are very real things. That the houses are so close to the street. You have a garage. You can't even pull your car out of the garage far enough to see before your car is in the street for some of the locations. Things are packed incredibly tight there. The streets are narrow, and it certainly maximizes the developer's dollar. But there's a lot of issues for the people that live there. And in addition, if you want to go to church, you have to leave Vineyard City. There are no church buildings in Vineyard. Vineyard specifically did not zone for churches. And so typically, again, going back to if you want to develop, cities often will say, well, you want to put in so many homes, you need to leave so much space for a church. And they don't have to donate that land to the church, to any church that wants it. The churches have to buy the land, but the land gets zoned as for church use so that it can be used for that. But Vineyard didn't do that. So I guess the question here is, do the citizens have any rights you feel have been violated by kind of the overzealous zoning? Or do the religious institutions, is there a claim for a violation of freedom of religion? Can cities just not zone for a religious building or institution to go in there?
Are cities obligated to zone at a certain percent for specific purposes?
So the question is, would the First Amendment, freedom of religion, require a government to allow for church type zoning to exist? Because if the answer is no, every city across the US could just say, we don't zone for churches here. And of course, not all cities do that. But the question is, does the First Amendment come in to start to compel cities to start to do certain things? Or does it give the cities the freedom to do whatever they want with zoning?
I think we've seen from a number of other example cases that cities can do whatever they want, it feels like. So in this case, I mean, I'm thinking of a situation in which, what if there's one sole landowner in Vineyard and the city is compelled to, find land to build churches on, and that sole landowner is the only one the only space available is with that one person. you know, I feel like it'd be really messy for the city to exercise eminent domain to force that person off their property in order to provide, you know, worship houses or whatever you want to call them. I don't know. That's what's going through my head right now. And what it's leading me to think is that a city is under no obligation to provide that, but I don't know.
So it's a really good point to look at, and there's a fine line here in what we're talking about, because we talked first how the city can come in and zone things. For example, they can designate a historical, and you lose all your sticks in your bundle except for the last one of ownership and maintenance, essentially. Here, if the city came in and zoned a certain portion of land, so if the farmer had all his land and they said, okay, you're the last homeowner, you know, the last owner with land, so we're just going to designate part of it as a religious zone for religious institutions. The fact it's zoned that way doesn't force them to sell it, and they don't have to use eminent domain to actually create it, but the city zoned for it, meaning they allowed for it to happen. If the city never zones for it anywhere, never designates any land anywhere as religious in nature, then has the city as a government entity just effectively abridged your freedom of religion at that point, because they have the power to zone and designate what goes where. And if they never allow for worship houses there, and again, this isn't to go to eminent domain, because there would be a lot of issues with eminent domain. But if they don't zone for it and don't allow it, is that similar to saying we've just banned religion in this, you know, assemblies of religion in this locality?
Well, so I have a question. They aren't necessarily preventing a religious institution to come to the planning commission and say, look, we would like to build a church here, right? I mean, there's
certainly nothing expressed.
What?
There's certainly nothing expressed, but they've never approved any yet.
Okay.
And so again, the question becomes, because what happens with zoning, it goes back to the racism type thing with zoning. Can cities have an ulterior motive for their zoning with the type of people they want to put in there, what they want to do? And so long as they never say it, as long as they never say, oh, we're against people of religion, or we're against people of this class or that class or whatever, then the law really lets them do whatever they want. But when you look at it and you say, well, why have you denied every church zoning request? It becomes an interesting issue. And so this issue is actually far more pervasive than vineyard. And this issue has been an issue now for a number of years with zoning. Because what a lot of cities did to stop churches from coming in is they banned steeples on buildings. And they didn't say steeple, but they said, we don't allow for any building to have something sticking up over 2 feet or whatever. You know, they made it generic. But ultimately, federal government Congress, decided that these were attacks on religion, that it was very much a disguised attempt to keep religion out of the cities. And they passed something that they call the Religious Land Use, I forget the exact name of it, but it starts with Religious Land Use something Act. And that act gave religions rights to have houses of worship built, and zoning, they could kind of force zoning exceptions for houses of worship when the city zones were written in such a way that it really targeted these. And so I'd say that the number one lawsuits that the Church of Jesus Christ of Latter-day Saints is involved in deals with zoning in cities that ban steeples or that really target houses of worship in a disguised way. And the church is very common in lawsuits against cities and counties, trying to get the right to have a house of worship built in that area. They were in a battle with Boston, I think, for 9 years in a lawsuit over the steeple to the Boston Temple. And so it is an interesting issue, again, with the power to zone. and inherently starting to recognize that at some point zoning can start to encroach on our constitutional rights. Obviously, it encroaches on private property rights, but it really gets into encroaching on some very, very deeply held constitutional freedoms for individuals. And it's an interesting issue. To my knowledge, Vineyard hasn't been sued over this. But I do think Vineyard would have some issues with the route they've chosen to go with the church side of things because of their, supposed oversight to forget to designate some of the area as religious. And again, Vineyard was built from the ground up with developers and people interested in maximizing that, and they zoned pretty aggressively. But it's just an interesting issue to look at with property rights. We are out of time today, and so again, we'll follow up each week. We'll go through some of these things. We'll talk through some of these issues, and again, the goal is to start to see these issues play out and recognize when they're happening, so that you can start to speak up. And as you share things here about the way you feel, it helps you start to understand more of what's happening. The background behind is gray, because a lot of these end up in the gray area where there's not an express law on things, on everything. But the law is going to look at a number of these factors. It's going to, and with Vineyard's case, it's going to go through, well, can you find any evidence of discrimination? How strong is the evidence of oversight or neglect? Are there any other options? How close are they? Are they really excluded? Is Vineyard small enough that it didn't need them? The law is going to go through all kinds of factors like that. But again, from a moral perspective and a freedom-based perspective, we have to recognize that even if the law allows it, we often need to speak out still, because at some point the law will stop when people speak up enough. And so for a lot of these things, we need to become diligent and starting to push to get, more checks and balances on eminent domain, more, some of the protections, talk about the basic things with HOAs, and perhaps put some of those in law to really balance the rights and interests that are associated there. But certainly appreciate your time today, and we'll follow up next Wednesday with more. Fridays we'll do this as well, but for just straight up constitutional issues. So if you have any questions in the meantime, let me know. But otherwise, we will talk to you later. Thanks so much.
Nicely done. Thank you.
Thanks,
Thank you, Austin.